Mr. Rees.
Before lunch, I was addressing on the Cayman Court of Appeal case of Telesystems and why there is a peculiar public policy in Cayman. And this was a decision taken in 2002, as I pointed out before lunch. But what the Court of Appeal in Cayman didn't take into account was the House of Lords decision in Luby, which is in bundle H2 behind tab 26, which will be a case familiar to this board. In terms of the relevant extract from this judgment, it's in the electronic bundle, page 2351, and the hard copy bundle, page 2311. And this is a page 2351 electronic, 2311 hard copy, is part of the speech of Lord Hope. And you'll see at letter D, he says under public interest, in my opinion, the principles on which the doctrine of forum non-conveniens rest leave no room for consideration of public interest or public policy, which cannot be related to the private interests of any of the parties or the ends of justice in the case which is before the court. And at letter H, the last two lines, he says, however desirable it may be on grounds of public interest or public policy, the litigation should be conducted elsewhere and not in the English courts. On the other hand, if the interests of all parties and the ends of justice require that the action of this country should be stayed, a stay ought to be granted, however desirable it may be on grounds of public interest or public policy, that the action should be tried here. And then goes on to say why he declines to follow judges in the United States who decide issues as to where a case ought to be tried on broad grounds of public policy. And so,
is that necessarily inconsistent, I wonder, with what the Cayman Court said? In the passage you took us to, they said a judicial system which perceived itself as powerless to intervene effectively to prevent the proceeds of a fraud from disappearing overseas would inevitably invite disparagement. Now, is that in terms of Lord Hope's judgment, is that a public policy which cannot be related to the ends of justice in the case before the court?
Well, I would submit that in light of the case of Luby, public policy arguments really shouldn't come into questions of forum convenience. And that's what Lord Hope says in that section, and indeed that was agreed to with by Lord Bingham at page 2346, e-bundle, page 2306, hard copy, where he says at letter E, both the plaintiff and defendants place reliance on public interest considerations to strengthen their contentions that these proceedings should be tried in the forum for which they respectively contended. I agree with my noble and learned friend Lord Hope of Craighead for the reasons which he gives. The public interest considerations not related to the private interests of the parties and the ends of justice have no bearing on the decision which the court has to make.
Yes, well, the only point I was making was to question whether the Cayman Court's dictum was actually inconsistent with that. So it might be said the public interest they referred to was related to both the interests of the parties and the ends of justice.
Well, I think the public policy reasons in Cayman have been set out in the argument of page 23 of the judgment of the appeal, where they're saying that in light of the fact that the peculiar structure of the companies in the Cayman Islands, where there's a requirement, if you look in about just over half of the way down this page, page 23, alleged by the appellants that over 90% of the Cayman registered companies are either exempted limited companies or non-resident companies, that an ELC must carry on its business mainly outside the islands, prohibited from doing business within the islands, save in furtherance of its business outside the islands. And so, in that case, there's a specific rule in Cayman, obviously, that they were prohibited from doing business within the islands, save in furtherance of its business outside the islands. And that's why the next paragraph of the judgment, the Court of Appeal, are taking the point that the trial judge had based his reasoning partly on the fact that 3 of the respondents carried on their business outside of the Cayman Islands, a forum non-convenience challenge by an ELC or NLC would always meet with success. I don't think that can be said of the BVI in terms of they don't have exactly the same type of structures. And so I think that's why there's a peculiarity to Cayman case authorities. And perhaps just to make good that point, I'll take you to a few more of the Cayman case authorities which refer to the fact that it's a unique system. But before doing so, and before leaving the case of Luby, can I just also draw your attention to the passage on E-Bundle 2347, hard copy 2307, where both Lord Steyn and Lord Hoffman agree with Lord Hope's position. And so we would say there is no public policy in the application of the Spilliano.
What was the public policy that was in play there?
This was Lord Hope deals with it.
Looking at the head now.
Yes, well, it was a case, as your Lordship will know, involving South African plaintiffs claiming damages in England for actions against English companies. And there was a claim for personal injuries arising out of commercial activities in South Africa of South African subsidiaries. And the actions were raising substantial and complex issues proceeding as a group action. And I think
they say it's rather like Vedanto.
Yes.
Yes, but what was being argued to be the public policy consideration which should for it to be tried somewhere else?
Was the funding unavailable to plaintiffs?
I mean, it's a completely different type of issue. Anyway, there we are. We see what it says.
Yes. Well, to make good my point in terms of Cayman being a unique in relation to these matters, perhaps we could look at the case of Cairnwood Global, which is at H2, page 32. Hard copy, page 2512. 2556. So, of course, this is a case 5 years after the Telesystems Court of Appeal decision. And so this is a first instance decision in the Grand Court in Cayman of Mr. Justice Foster. And so, of course, he had no room to manoeuvre other than to follow the Court of Appeal case 5 years earlier of Telesystems. And this was a case involving a forum convenience argument, and whether the Cayman Islands were the appropriate forum, and the action was to determine the duties of directors of a Cayman company. This is different to this case, of course, but this is not about an action to determine duties of a director of a BVI company. And so you'll see over the page that what the headnote says, and the second paragraph on that page, is it was particularly desirable that the duties of directors of Cayman companies be determined by the courts here, given the state of the Cayman Islands as an international financial centre. Well, that's repeating what the Court of Appeal had said 5 years earlier. This was well established as a matter of public policy and law, and therefore this court was prima facie the appropriate forum for the trial of the plaintiff's actions. And then it goes on to say, one sentence after, in addition, the plaintiff's agreement with his manager was expressly governed by Cayman law, and his claim for breach of trust might not, in the context, be familiar to the Georgia court. So there's a particular agreement whereby the contract was governed by Cayman law. And then there was also an indemnity involved in the case. We see that further down the footnote. Sorry, the head note. And this involved the application of an investment manager of a fund in the Cayman Islands again, very different to the application of the facts of this particular case. And if I can ask you to look at page 2526.
The electronic page?
2570. Sorry, my lady. Mr. Justice Foster, he refers to the service out rule in Cayman, paragraph 36, and it's the last 3 lines of paragraph 36, where he mentions there that is implicitly reflected as the apparently unique to the Cayman Islands additional ground on which it is permissible, with leave of the court, to serve proceedings out of the jurisdiction provided for in the Ground Court Rules, Order 11, Rule 1, subparagraph 1, double F. And so that particular ground for service out is different and distinct from the ground for service out in the British Virgin Islands. And so the British Virgin Islands have not adopted that much wider ground for service out. And you can see that ground, which is in the hard copy bundle, in the case of TCP Creditor Recoveries Limited and Arthur Anderson, behind divider 33, and it's page 2535 of the hard copy bundle. 2580. And over the page is where you'll see the double F rule in Cayman, which is different to the one in the BVI. So double F says the claim is brought against a person who is or was a director, officer or member of a company registered within the jurisdiction, who or is or was a partner of a partnership, whether general or limited, which is governed by the laws of the islands, and the subject matter of the claim relates in any way to such company or partnership, or to the status, rights and duties of such director, officer or partner in relation thereto. And the first instance judge, Justice Levers, Madam Justice Levers, says in the judgment, page 2558, hard copy, (2603), please, B bundle, where at line 8, she says, in England, the case of Luby and others and Cape PLC makes it clear that public policy is not a consideration, but in this jurisdiction it would appear the Chief Justice in KTH Capital Management Limited and China One Finance Limited made it clear that public policy is a consideration that should be taken into account, as did the Court of Appeal in the case of Contadora Enterprises and Chile Holdings, and sets out the reference and the citation there. So, in summary, we'd submit that whilst it's all very interesting to look at the Cayman case authorities, it doesn't actually take us anywhere in our respectful submission, and that Cayman is a peculiar, or to use the words of Mr. Justice Foster, a unique situation, and so it is not a comparable which we would submit is open to the appellants in this case to rely upon. Moving on then, if I may, to deal with more general grounds and deal in terms of the appeal which is being brought. In looking at the judgment of the Court of Appeal as a whole, we would say this is a well-considered, well-structured, well-thought-through judgment. It's clear from the paragraph which deals with exercise of discretion, paragraph 20, which is e-bundle page 46, hard copy 42, that they knew full well what their position was as an appellate jurisdiction. They were exercising their discretion with caution. If I may give you again the reference, paragraph 20 of the judgment of the Court of Appeal, hard copy, page 42, e-copy 46.
E46, did you say?
My Lord, no. It's e-bundle,
Yes.
page 46, sorry. It's hard copy, page 42, which is volume A.
Sorry, volume?
It's the Court of Appeal judgment in this instant case.
Oh, right.
Sorry.
That's,
Yes, tab 5, my Lord.
fine, thank you.
So going through the judgment, if I may, of the Court of Appeal, just to elucidate some of the points which the Court of Appeal found. In terms of the exercise of discretion, much is being said against the Court of Appeal. They should not have re-exercised their discretion. But for the point that I made right at the outset, they really hadn't any choice. And so the question is, when re-exercising their discretion, were they right in how they approached it? So, if one goes through, obviously, we're not going to go through, go to the first stage analysis, which is paragraph 28 of the judgment. So, stage 1 is Russia as an available forum and the expert evidence. There's a considerable amount of analysis in the Court of Appeal judgment, which goes over to paragraph 39 on this particular stage. And in our respectful submission, they've taken it carefully. They've looked at all of the evidence of both of the experts in Russian law, and they've come to an evaluation and analysis, which, paragraph 36, of the judgment, you'll see, with reference to the case of VTB Capital and Nutritech International, following the first instance decision of Arnold J., Mr. Justice Arnold, they're entitled and obliged to consider the quality of the evidence, taking into account factors such as the experience of the experts, the cogency of the reasoning, and materials relied upon to support it. So they've gone through this analysis quite carefully in terms of the expert evidence in the case. And at first instance, Mr. Justice Wallbank was prepared to accept, and this is page 34 and 35 of the transcript, for the purpose of the inquiry, he was prepared to assume that Russia might be an available forum of competent jurisdiction. So the Court of Appeal have come to the same conclusion.
That was in the context of the service out.
It was, I accept that, yes.
Surely
Yes.
it was wrong to jump from that to this case, which is a different proposition, isn't it?
Sorry?
I mean, I don't see how they could have used that in the different contexts that they were faced with, which was to decide positively whether Russia would be a suitable jurisdiction.
Yes. I think the analysis at this stage is simply whether it is an available forum. And then you go to the next stage of whether it is the appropriate forum. That's how the Court of Appeal have phrased it in stage 1. It is Russia an available forum and the expert evidence. And so if one looks at the expert evidence on this point, it's in volume F. And behind, firstly, in the e-bundle is page 1352. And in the hard copy, it's 1309. And I'm taking you through various stages before I get to the joint expert report later on.
But I mean, we can't possibly evaluate the expert evidence. I mean, the judge, that was the judge's job, but he said, as he hadn't been able to test it, he couldn't make a final conclusion. How are we going to do any better than that?
Well, the Court of Appeal, obviously following the decision of Mr Justice Arnold in VTB Capital at first instance, at paragraph 36 of this Court of Appeal judgment, said that they were entitled and obliged to consider the quality of the evidence, taking into account factors such as the experience of the experts, the cogency of the reasoning, and materials relied upon to support it. Because what Mr Justice Wallbank did at first instance was says, I can't make up my mind, it's impossible. Both seem to be arguing contra points. How do I decide it?
Well, he did what he had to do, which was look at the expertise and see if he could reach a view.
Yes.
Without it being tested by cross-examination.
Absolutely. And that's what
he couldn't.
I agree. And that's what Mr Justice Webster did. And he obviously was in just as good a position as Mr Justice Wallbank was at first instance, because all of the documents, none of this is in terms of factual live evidence. And so he took the view in evaluating the cogency and the reasoning and the materials available to the experts that he could make the finding he did at the end of paragraph 38 of the judgment of the Court of Appeal, when he says, I think about 6 lines down, I would go one step further and draw from the conflicting evidence that depending on the evidence before the courts in Russia, there could be either a single trial of the defendants before the Russian court of general jurisdiction, or, if the claims could be split, separate trials with the foreign defendants being tried before the arbitrage court. And then he goes on to say, the latter part of this finding, split trials, is very similar to the judge's observation at page 23 of the transcript cited in the preceding paragraph.
If I remember correctly, didn't the case have to be one of either wrongful acts being committed in Russia or a loss being suffered in Russia in order for the Russian courts to have jurisdiction?
Or both.
Or both, yes, yes, indeed both.
Yes, and the judge wasn't satisfied that either of those was the position.
Couldn't hear the last part.
I had the impression that the judge, and for that matter the Court of Appeal, I think, weren't able to be satisfied that that was in fact the position.
Now, I think the Court of Appeal were able to go further than what the first instance judge did, because he simply put his hands up and says, I find it impossible to judge between these two competing experts.
Yeah, but they were at odds. I thought they were ad idem in saying that there would have to be, the case would have to be one being put on the basis of commission of delicts in Russia and loss sustained in Russia in order for the Russian courts to have jurisdiction.
Weren't they acknowledging the same thing as well? Because if you look at paragraph 38,
yes,
there is a very important qualification, depending on the evidence.
Yeah.
And then it's arguably a non sequitur at 39 to say, and so I find it's available.
Well, obviously I can't put words into the judgment.
But you are interpreting this.
Yes, yes.
And in so doing, surely you have to deal with depending on the evidence.
Well, I think the point, if I can make the point by reference to the joint expert report, then you may be able to see where Mr. Justice of Appeal Webster was coming from. If I go straight to the joint expert report rather than go through the analysis.
Or do we need to? I mean, paragraph 32, one expert in the last sentence is saying, yes, jurisdiction, if at least part of the losses were suffered in Russia, or some of the tortious actions were committed in Russia. The other expert is saying jurisdiction in Russia if the torts and the losses took place in Russia. So for one of them, either will suffice, for the other of them, both will suffice. But for our purposes, it doesn't seem to matter very much which of them is right if it's not clear to us or clear to the judge that either of those conditions is met.
Well, on the evidence from the joint statement, if I can take you to it, it's in e-bundle page 1483, hard copy 1439.
When you say e-bundle, you mean electronic?
Yeah, so forgive me, yes.
Yeah.
Ah,
It's actually in bundle F,
Yes, well, that,
page 1439, hard
That's the
copy,
problem, yeah.
sorry.
Electronic.
Electronically, it's page 1483.
yes, it's quite confusing.
Forgive
Anyway, bundle
me.
F. Yes, page?
Page, hard copy 1439, please.
Joint report.
It is, my lord. So it's paragraph 7A. So it says whether the claimants will be able to consolidate all of their claims against all defendants, both Russian and non-Russian, and bring such claims to one Russian court. And so this is the paragraph I understand Mr. Justice of Appeal Webster was referring to when he came to the conclusion he did at paragraph 38.
Part of this would you like us to refer to in particular?
The second bullet point, Mr. Kulkov is of the view that claimants would be able to consolidate their claims against both the Russian and non-Russian defendants. Such consolidated claims will fall under the jurisdiction of the Russian courts of general jurisdiction. And since under Russian law all defendants bear joint and several liability, Russian courts of general jurisdiction would not refuse to accept claims against non-Russian corporate defendants being consolidated with the claims against Russian defendants. I mean, the evidence which the Court of Appeal accepted from all of this different analysis between the Russian law experts was that there's either going to be a consolidated claim with all defendants there, or be a split claim with the Russian domiciled defendants being dealt with by one court and the international defendants by the arbitrage court.
But it's in that second example that he puts the qualification on, provided that some of the losses are suffered in Russia.
Yes.
You've got the first one, which you've just taken us to, I think
Yes.
it's in 30, isn't it? In 30 of the Court
My
of
lady,
Appeal.
yes, it is.
And this is the alternative position.
Yes,
If he's wrong about that, then
yes.
at least some of the losses or some of the tortious acts have to be in Russia. So where's that in the report then, if you're saying the report's the answer? I think it's the next paragraph, isn't it? B,
Yes, it
Mr.
is.
Kulkov.
It is. Yes, hard copy, page 1440.
So the Court of Appeal then jump in paragraph 39 to the conclusion that Russia is available.
Yes.
And I think what I was putting to you earlier was that might be a non sequitur.
Well, it is available as a forum. It's either going to be consolidated between both, as in all defendants put together, or it'll be split. And ultimately, the Court of Appeal took the view, well, that still amounts to substantial justice.
well, we're
And
not
we'll come
reading
to
that here.
in a moment.
We're not reading that here. I mean, these opinions are based on hypotheses, or in the case of Professor Asoskov.
Yes.
And in the case of Mr. Kulkov, it's conditional on where the losses were incurred and where the delictual actions were committed. But it's those facts which the judge was unable to determine, unsurprisingly, at the preliminary stage.
And similarly, the Court of Appeal was, because they agreed about that, didn't they?
Well,
I mean, is there anywhere in their judgment where they say, we differ from the judge, we can say that some of these matters took place in Russia, either the torts or the losses?
well, in terms of the well, they go through in paragraph 46 of the judgment the difference between Russian and BVI and legal principles applicable to the claims and available remedies.
The Court of Appeal does not indicate that the advantages and disadvantages of the split trial, nor does it go back to this point that there may be found to be a reservation that the loss must be incurred in Russia and the defendants' tortious actions must have occurred in Russia. When the Court of Appeal at 38 says that Russia would be an available forum, it hasn't taken into account any of those points.
They make it particularly clear, perhaps, in paragraph 45, where they say that in the absence of direct evidence of the place of commission of a wrongful act, it's tempting to accept the BVI defendant's submission that the wrongful acts were committed in Russia, submission to infer that the wrongful acts were committed in Russia wherever Russian defendants resided and worked. But I think that borders on speculation.
Yes.
I prefer to take the position there's insufficient evidence to upset the judge's finding that at this stage the place of occurrence cannot be determined with any degree of certainty. The result is that the place where the wrongful acts were committed can't be used as a prima facie indicator of a more appropriate forum.
And again at 47.
Yeah.
And it was, at least on one of the experts' cases, it was that you had to have both the place of the tort and the loss in Russia. So this has destroyed an intrinsic part of that twofold condition.
But it was, in my respectful submission, still open to the Court of Appeal to make the finding that they did at paragraph 38. And they were in just as good a position as the first instance judge was, because he was on the documents. In terms of the stage 2 process as set out in paragraph 40 onwards of the Court of Appeal judgment.
Could you just
yes.
humour me for a moment? If you're wrong about that, and Russia isn't an appropriate, it isn't an available forum, it stops there, doesn't it?
It does.
Yeah.
Then stage 2 is the appropriate forum, the connecting factors. Again, we would say that the Court of Appeal came to the right conclusion in relation to this stage of the analysis in terms of when they were looking at the case, as is set out in paragraph 41, the top of page 52 of the hard copy document, page 56 on the electronic portal. So the determination of who are the persons who directed the companies in perpetrating the scheme must therefore be judged by reference to the de facto directors. It is not disputed they lived and worked in Russia during the relevant period, which, on this particular case, it's an accepted fact, obviously, that both defendants were resident in Russia. I mean, it's also asserted that they travelled a lot as well, but in terms of their domicile, it was Russia. And so in terms of any act being done by any corporate entity, it would have been through those individual defendants. Defendant 8 and 9 in this
if I may
case.
say so, you have to read the rest of the paragraph. However, the evidence that's available to the claimants points to the tortious acts and breaches of trust having occurred in places other than
Yes.
Russia.
No, exactly.
There is no evidence that any of illegal activities took place in Russia. In short, Russia is not the place of commission of a wrongful act.
Yes, no, I accept that.
Well, okay.
Is that a submission that's being made? Are they reporting a submission there?
I accept
beg
this in
your-
the judgment, of course, yeah.
Well, yes, but I think that's what the claimants are asserting, isn't it?
Paragraph
Are you
41.
yeah. Because then it says...
Oh, I
next
beg your,
from the
I beg your
defendant's
pardon. That
counter.
is, yes, you're quite right. Yes, when you read the first
I
sentence,
think so.
it is summarising the claimant's case. Yes. So you can withdraw the concession.
Yes. Yes. I hope the concession was simply that it was in the judgment, and I apologise that I hadn't read the next line to put it in proper context.
Oh, no.
And so, moving on to the governing law of the claim and the action, again, the norm would be to look at, in a claim for tort, the place of commission of the claim, and they, respectful submission, they looked at that, but they accepted the first instance judge's assessment that he couldn't make a specific finding.
Where are you now? Which paragraph?
Well, I'm going from paragraph 46 of the Court of Appeal judgment, which is electronic bundle 57, hard copy 53. But what the first instance judge did was he said, well, I simply can't make a decision on the governing law. And we would submit that was an error, because you have to do it, or have to do your best if you can. And we say that he could and should, at first instance, have found the governing law. And because of all the connecting factors, which I've set out in the written case, and it's also in the 18th respondent's written case in terms of the facts, we say that the governing law in this case should be Russia.
Why must a judge make his or her mind?
Well, it's part of the analysis, obviously, under Spiliada.
Assuming the judge feels inadequately informed to make his mind or her mind up.
I understand, in that, in this particular case, if the first instance judge said, well, I can't possibly make any determination at this stage, in this case, on the governing law, then it is one of the evaluative stages in the Spiliada test, but it may be that they can't come to a conclusion on it, and therefore they move on to another stage of the Spiliada test, and it's overall the weight and balance to be given to all the considerations, I suppose. And so, but we say that in this case, the Court of Appeal could, and obviously did, make a finding on governing law, and that is not one which is so clearly wrong that this court should interfere with it. The case on witnesses, which is also a factor obviously in the Spiliada test, I don't propose to address you at length on that because it's already set out in the written cases, and indeed is set out in the judgment of the Court of Appeal. And so if we move to the stage 3 analysis, which is a paragraph 75 of the Court of Appeal judgment, electronic bundle page 67, please, and hard copy 63. We say that the Court of Appeal set out the right legal test there in terms of can substantial justice be obtained in the appropriate forum, and have applied the right legal test in the application to the facts of this case, based on their assessment and analysis of the expert evidence. In particular, paragraph 80 of the Court of Appeal judgment, electronic bundle 70, hard copy 66, we deal with the issue of limitation there, in terms of the Court of Appeal deals with it there, and the Court accepted the undertaking that the issue of limitation would no longer, therefore, be a serious consideration. And in terms of the assessment of the ability to obtain substantial justice, they looked at the case of Connolly, which is a well-known case in this jurisdiction. This court will know well about that case. And it's all about whether substantial justice will not be done in the natural forum. And so in this case, having assessed all the evidence and the considerations, and looked at all the expert evidence, they came to the conclusion, we say correctly, that there could be substantial justice in the appropriate forum.
Do you want to say anything about the unavailability of equitable and proprietary remedies in Russia?
Well, I think the expert evidence is, and I can look it up on this particular point, they have, whilst they don't have the concept of constructive trusteeship as such, they have something quite similar to it.
Well, what we're told at paragraph 79 by the Court of Appeal is an important part. It says the claimants will have fewer remedies in Russia. An important part of their claims in the BVI is the remedies of a constructive trust and the tracing of assets. It's common ground that these remedies are not available in Russia. We saw it this morning how the reports available to the claimants indicate that the bribes that have been identified have passed through various people's hands and are now if they're recoverable now in the form of property around the world.
Yes.
Unless you have a personal claim against somebody who is good for the billions of dollars involved.
Yes.
So the absence of trace, the inability to trace, in other words, and then obtain a proprietary remedy could be a matter of considerable importance by looking at things.
Well, the evidence on that is at page 1487 in electronic form. Page 1443, hard copy. F, please. So it's
So where's he dealing with proprietary remedies?
looking at the question of constructive trust and tracing of assets at paragraph 15 of this report.
Can you give me the electronic page number for that?
Yes. 1487, my lady.
Thank you.
Yes, they're talking about the availability of damages, restitution,
Yes.
and an accounting. An accounting for profits.
Yes. Well, paragraph 16 as well, it deals with that point.
Yes.
There. I noticed the time, and I was going to hand over to Mr. Moberly Smith,
Very well.
who has, of course, been engaged in this case for, I think, 4 or 5 years,
Yeah.
and I've only recently come into it. So it may well be that he can assist you further in
Fine.
relation to this aspect of the case.
Thank you. I should just ask your junior, Mr. Cruikshank, if he follows. Thank you. Yes, Mr. Moberly Smith.
It's convenient to the board. What I was proposing to do was to deal first of all with whether or not the Court of Appeal was entitled to submit its own exercise of discretion in place of the judge's exercise of discretion.
Yeah.
Secondly, deal with the available forum. Thirdly, with the applicable law. Fourthly, with jurisdiction incorporation.
Yes, of course.
I can deal with some of these matters quite rapidly. In relation to the ability of the Court of Appeal to exercise its discretion in the place of the judge's discretion, that turns on the fact that the learned judge did make an error of principle in taking into account the fact that the claimants had chosen to sue in the BVI that should be an important factor. That is something that the Court of Appeal disagreed with, and the fact that the Court of Appeal said that wasn't a factor to take into account is something that hasn't been appealed to this Court. Therefore, as things stand, it must be accepted that the Court of Appeal was entitled to substitute its own exercise of discretion.
I mean, that can't mean they can throw away the whole judgment and start again, does it?
Doesn't necessarily mean they can throw away the whole judgment, but what they can do is to see whether or not, in the way the judge exercised his discretion, he did so on basis.
Well, I mean, you can make your point about that and say the judge gave too much weight to it. Well, one's got to see what part it played in the judge's overall exercise of judgment.
I think the difficulty is, unless the judge says this element is 10% and that element is 20%, it's difficult to know precisely. Thank you. It's difficult to know precisely how much emphasis the learned judge placed on that factor.
Applies to any judgment. One's got to exercise a degree of common sense. I mean, you may be able to show us that was a fundamental part of his reasoning, but it didn't get that impression.
What the Court of Appeal found was there were 4 grounds on which the learned judge went wrong.
Yes.
And one of those grounds was the failure, was to take into account the fact that the claimants had...
yes, that was one of 4 factors. So
well, yes. The other factors were not making a finding about governing law,
yes.
failing to conclude Russia was the law that governed the claim, and attaching too much weight to the domicile of incorporation.
Yeah.
So those are the factors. And as I say, once you get beyond the point of finding that the learned judge has made an error of principle, then the Court of Appeal is entitled, in my respectful submission, to substitute its own views as to the weight to apply to those factors that should have weight applied to them. Before they get to that part of the exercise, the first thing I need to establish is whether or not Russia's an available form at all, because if it isn't, then the argument falls away. And in relation to that, it is the case under Russian law that there's an alternative in relation to whether or not a claim can be brought in the arbitrage court. So the alternative is, first of all, that loss has been suffered in Russia, or, as an alternative, that there's a tortious act that's been committed within Russia. And those are alternatives. I think,
I think according to one expert, they're alternatives. Didn't the other expert put them as cumulative?
That's not correct, actually, because I think if you look at the expert evidence of Professor Asoskov, who was the expert for the plaintiffs, you'll find this is in bundle F at tab 70, at paragraph 76, 1438 of the electronic bundle, and page 1394 of the hard copy.
Was it also in their agreement?
I don't think it's been put. I think it's slightly ambiguous in the in the paragraph you looked at in the joint report. But this is Professor Asoskov, so the claimant's expert, and he is saying at page 1438, and certainly the expert for the defendants agrees with this, that there are 2 alternative grounds of jurisdiction. Paragraph 76.
Yes.
Sorry, could you give me the electronic page again?
Sorry, 1438.
Thank you.
Yes.
Now, in relation to where the acts took place, both the learned judge and the Court of Appeal formed the view that they couldn't form a view. And therefore, I think that ground falls away. But in relation to where the losses were incurred, that reflects where the victim is. And therefore, one has to then see what is pleaded about who has suffered the loss. And of course, this is a provisional view, but on the face of it, a loss has been suffered by both defendants, both claimants. And therefore, if you turn to the pleadings, which is bundle D at tab 31, you find the claim form at page 927, which is 946 in the electronic bundle.
I'm sorry, which volume is this?
So I'm now in the pleadings volume, so volume D, tab 31, bundles.
31.
Tab 31, and it's page 927 in that bundle, where the claim form starts. And one can see, if we turn to the following page, there are two claimants, one of which is JSMCC Eurochem, with an address in Moscow, and the other is Eurochem Trading, with an address in Zug in Switzerland. And then one turns on to the next page, you can see it says, in the plural, the claimants suffer loss in the following ways, and then the subparagraphs for claimants in the plural lost sales. The claimants in the plural will suffer further loss. And then as you turn through, you can see the same formulation in paragraph 8.1, claimants in the plurals, products being purchased at an undervalue, claimants in the plural losing sales and so forth. And then all the pleadings in relation to loss and damage are by reference to both claimants. So therefore, on the face of the pleadings, you have prima facie loss being suffered by the victim, a Russian company in Russia.
Well, does that follow?
And
I wonder if that follows. The claimants lost sales in those markets where the fraudsters effectively were active. I mean, does it follow the losses suffered in Russia? You think about how companies operate these days with transfer pricing and so forth. One wouldn't necessarily take it for granted that the place where the company is incorporated is the place where it suffers losses if it's trading globally.
well, I can fully understand that it may be the case that losses are suffered elsewhere. It's never been denied by the first claimant that it hasn't suffered any loss at all in Russia. And according to the defendant's expert, it's enough if there was some loss suffered in Russia.
Did either the judge or the Court of Appeal find that, as a fact, that losses had been suffered in Russia?
Well, of course, at this stage, one's looking at a provisional...
Oh, look, well, yes, so on a provisional basis, did they reach that view?
A question of impression. Well, I think the position is that it wasn't... I think the experts indicated there were those two bases. The Court of Appeal had found that one of those bases wasn't something it could make any finding about, namely whether there was any tortious act in Russia. Therefore, it must follow that they proceeded on the assumption that there has been loss suffered in Russia.
Yes, but what the professor said was that in his second of the two alternatives was jurisdiction at the place where losses were incurred by a victim. He doesn't say where any of the losses were incurred. He just says where losses were incurred.
That's exactly right, my lady, because the difference between the experts was whether or not there was a preponderance of loss suffered by the victim in Russia, or whether, as the defendant's expert would have it, there was some loss suffered by the victim in Russia.
But either way, it's not 100%. Preponderance or some is not 100%.
Of course. Ladyship's entirely right. So you don't need to suffer all your loss in Russia. You need to suffer some. And I think the problem with preponderance, and this is one of the points that I made in the Court of Appeal, was you would then have a situation where, depending on what losses you discovered as the litigation unfolded, the jurisdiction of the Russian court could evaporate because you discovered, for instance, you had suffered more losses outside Russia, and suddenly the preponderance wasn't in Russia, and the jurisdiction had gone, which would be an impossible situation, and therefore, on that basis, one anticipates that the learned judge in the Court of Appeal took the view that preponderance maybe couldn't be the test, and therefore some loss was sufficient to establish jurisdiction.
In the next sentence, he tells us that background facts, by which he presumably means the facts as per his instructions, do not support application of any of these grounds to the present case. He was obviously aware that one of the claimants was a Russian company. So that wasn't in itself, it's implicit, that can't in itself be enough to support the application of the the relevant Russian rules of jurisdiction to this case.
Which is borne out, isn't it, by paragraph 33 of the Court of Appeal? By the time they've digested it, they have actually translated it, you say wrongly, into both the tortious actions and the losses have to occur in Russia, and then say, well, that's criticised because it's on instructions, but then, says the judge, I'm satisfied that's an evidence-based conclusion.
I read that paragraph as the learned judge essentially recording what Professor Soskov disagrees with, but I take your ladyship's point. He does use the words evidence-based conclusion.
Yeah.
And that might be by reference to both elements.
I mean, just to unwind it, am I right in thinking in the joint statement of the experts, it had got translated into both the tortious acts and the losses had to occur in Russia?
I think that's certainly not how I remember it.
Okay, well, I'm asking, not in any way suggesting that I know. I can't remember the page number for the...
14848. Yes, it's subparagraph B. And the confusion is that they use a semicolon paragraph 7B.
I don't think I got the right page. I think we're on the usual problem of
So
electronic
14,
versions.
1440 in the hard
Yeah, I thought it was. Thank you.
electronic copy.
Sorry, what was the electronic page then?
1484.
Thank you.
Thank you. And what I was saying was subparagraph B,
Yep.
unhelpfully uses a semicolon, which I suppose might be or and.
Yeah. But we're in some difficulty going back to the original experts' report and second-guessing the Court of Appeal, aren't we?
Exactly. So the extent to which you can intervene is limited by reference to what you're really able to do in terms of assessing whether or not the Court of Appeal was able to come to the view it came to. Because Mr. Kulkoff, on that very same page, definitely has them as alternatives. He says, if at least part of the losses were incurred on the territory of Russia, or at least some of the tortious acts were committed in Russia. So if the learned judge in the Court of Appeal was taking the view that he preferred the cogency of Mr. Kulkoff's evidence over the cogency of Professor Soskov's evidence, then he was entitled to form the view as long as some losses were incurred by the claimants, which is, let's say, supported by what, on the face of it, supported by what the pleadings say, then that was sufficient to ground jurisdiction.
But he was saying he wasn't resolving conflicts between the experts at 38.
I think what he says is he's not resolving conflicts, but he's considering a cogency and making preliminary findings.
Okay.
Sorry, 38 is what he says the judge was doing.
Yes, but he says the judge was right in his approach.
He says the judge was right, but what he says is that they can guide him in considering the issues without actually preferring one expert's evidence over the other. And if you look back to paragraph 36, at the end of that paragraph, he says that it's important that Mr. Justice Bank didn't make specific findings on the disputed expert evidence, but considered the cogency of the evidence, as he was entitled to do. So clearly, Justice of Appeal Webster was taking a view that you didn't have to take it simply as an impossibility in terms of deciding which expert to prefer. You could take a view of the cogency of the argument. As I say, the problem with Professor Soskov's argument is the preponderance of damage kinds of problems that I just described. So that's where I think where we get to in relation to available forum. Clearly, the Court of Appeal was entitled to take a view about the expert evidence and decide whether or not the forum was available. And the only issue, I think, when one analyses it, is that issue about whether or not there is some loss that can be identified on a preliminary basis as having been suffered in Russia. If you've done that, you've got an available forum. It does give rise to the question, if that is wrong, what then happens? Does the board then refer the matter back to the court of first instance to re-exercise the discretion? We would say, as things stand, the exercise of discretion is entirely supportable by the expert evidence, and the fact there was one expert who supported the proposition of jurisdiction. If I can move on quickly to applicable law.
Yes.
So what's the burden of proof on showing available forum?
It depends who you're looking at. I mean, the difficulty I had was I was acting for both the service out defendants and the stay defendants, if I can describe them that way, in the Court of Appeal. So
right.
I was riding two horses.
All right, but if on the stay application,
So
the burden of proof is on the...
On the stay application, the burden of proof is on the party seeking the stay.
Right, and to what level does what is the standard of proof then about the Russian forum, available forum? How does it have to be shown on a balance of probabilities? Or only that it's something less?
In terms of any authority that actually deals with it, I can't off the top of my head think of any authority that actually analyses precisely what needs to be done. I think it says the burden is on, is how we describe it. So I suppose that assumes the balance of probabilities on the available material.
Yeah.
Because it's obviously qualified by the fact you're at the very, very start of the case, and therefore things may change. And obviously in relation to service out defendants, there the burden is on the claimant to show that the alternative form is not available, it is otherwise appropriate. In terms of applicable law, Justice of Appeal Webster had dealt with this at paragraphs 56 to 60. So I must get my page references right. So it starts at paragraph 46. Where he carries out an analysis of the principles to be applied. And then from paragraph 52 onwards, he deals with tort, and then goes into the question of the double actionability rule and exception to that. But along the way, he also, at paragraph 54, advances this proposition that the governing law in restitution is the law of which the obligation has its closest and most real connection. So he wasn't only dealing with the question of tort. At paragraph 60, he concludes, having carried out that exercise and having looked at the terms of the contracts of employment and the fact that those contracts contained wide-reaching choice of law provisions that extended beyond the terms of the contract to the relationship both for Mr. Rogowski and for Mr. Potemkin. And looking at all those elements, he concluded that Russian law was the governing law of the claims in relation to the action as a whole. Now, of course, the exercise he was seeking to carry out was to see whether or not there was a specific law that the claim was most closely related to for the purposes of determining which jurisdiction was the best jurisdiction for the trial to be heard. And so it's a preliminary view, essentially weighing up which jurisdiction satisfies that test. The purpose being that if you are a court dealing with foreign law, you need to deal with it by reference to expert evidence. If it's your own law, you don't need expert evidence. You've obviously got much greater familiarity with the legal concepts, and that's the reason why it's a very important factor in relation to forum challenges. So he was looking at applicable law in that context, and as I say, wasn't only looking at tort, he was also looking at restitution, which is the other element of the claim. And there's been no challenge to the proposition that in relation to restitution, one does look at the closest and most real connection. The board obviously could form a different view, but is only entitled to substitute its own view if it's established that the Court of Appeal have erred in the analysis that they have advanced. In terms of the double actionability rule and pleading, double actionability does mean that the claimant does need to show that there is a claim that can be made both in the Lex Fori and in the Lex Loci Delecti. And in relation to the Lex Loci Delecti, what needs to be shown there can be shown at trial if there's no other evidence by the presumption that the foreign law is the same as English law. But that's a question of proof at trial. It's really got nothing to do with the prior question, which is which law on the face of it applies. Mm-hmm. And as I say, with double actionability, you need to have both legal systems analysed. Looking at the exception to that rule and looking at closest connection, we would accept that the learned judge has perhaps gone down an unusual route in the sense that he's now looking at the way the double actionability rule works, which really isn't necessarily a relevant consideration. The relevant consideration is this the law that's most likely to dominate the trial? But looking at it in that way, he was quite able to form the view that Russian law would dominate the trial for the reasons he gave. In terms of pleading, the Court of Appeal decided that the question of whether or not a claimant needs to plead foreign law was a question of great general public importance. With the greatest respect to the Court of Appeal, that's really an irrelevance to this exercise. Because whether or not foreign law is pleaded, the question is what's going to happen at trial. Is it likely at trial that the law that the court's going to be most concerned with is Russian law? And the fact that at the very start no one's pleaded foreign law is really neither here nor there. So that's what I was going to say about applicable law. In relation to
I'm sorry, you're saying that the proper inference is that the governing law would be Russian?
The governing law in relation to restitution would be Russian, applying what the learned judge...
Against the recipients of the bribes?
Against the recipients of the bribes was the proposition that the Court of Appeal had advanced, which hasn't been challenged. What's been challenged is in relation to tort and how the learned judge focused on tort.
I thought it was all delictual claims. I thought it was all delictual claims, that the only express provision for choice of law is in the employment contract. Yes. The employment contract purports to cover other claims.
Yes.
And so far as third parties are concerned, that can have no effect, surely. Well, that would be a matter of perhaps of Russian law.
Exactly, yes.
Whether it would have any effect. But then if it didn't have any effect, you'd have to have a separate substantive proper law
I agree entirely.
For the claims against third parties.
Yes. And it may be in those circumstances you would have to introduce another legal system, another law. So the Russian court would have to consider, if it's in Cyprus Cypriot law, as to constructive trusts.
If it's in the BVI law.
And if it's in the BVI law, yes, of course.
But was there any expert evidence about the status of that clause in the employment contract, saying what Russian law would make of that clause?
I don't recall that having been focused on by the parties, and therefore not focused on by the experts. I think you're entirely right, lady.
Yeah, so
Yes.
certainly nothing's been drawn to our attention to suggest that Russian law would regard that as binding on any third-party claim.
No, and I fully accept what your ladyship says, that it may be that the closest connection in relation to the third parties is not Russia, and may be another jurisdiction.
But how did the Court of Appeal then come to its conclusion at paragraph 60? Because having cited the employment contracts and the clause 8.1,
Yes.
and it also adds the framing of the claims in the amended statement of claim, which I don't think adds. Justice of Appeal Webster says, I'm satisfied that the disputes between the claimants and the Russian defendants arose out of the employment and would be covered by the laws of the Russian Federation. And then he says, I would hold that the Russian law is the governing law of the claims in the action.
So I think that depends, my lady, on whether or not the last sentence is purely a conclusion reached by reference to the previous sentences of this paragraph, or whether it's referring back to all the matters he's addressed, going back to paragraph 46.
Yes.
And if it, in my respectful submission, it almost certainly is, because he's seeking to conclude what the position is in relation to
All the claims.
the question he's asked himself.
Yes.
What's the governing law? So I think that sentence probably ought to be in a new paragraph. I think
Yes.
if it is in a new paragraph, it then makes sense.
Correct. But then what is the evidence for saying that Russian law is the governing law of the torts that are claimed?
Claims. Well, in relation to tort, what he's done is to, I think, look at whether or not the BVI court would apply Russian law, and has taken the view that Boys and Chaplin permits him, where you can't determine the lex lecti, where you can't determine that, then you can apply the exception, and in applying the exception, the BVI court would then look at the closest connection.
But these may be bribes paid to people in numerous parts of the
Well,
world.
ladyship's entirely right, and at the moment, nobody's in a position to know what other jurisdictions are
There was
involved.
an indication in Bulgaria and goodness, and lots of other
Yes.
people.
And what those legal systems do about some of these issues is very, very difficult to discern. And so what you have is a situation where you can't say, in relation to the tort, what other legal system will apply and how the double actionability rule will apply, because you can say, yes, it will, in relation to a bribe, yes, you've got a cause of action in the BVI, but in relation to the foreign jurisdiction, you don't know because you don't know where it is. And therefore, what Justice of Appeal Webster has said is that in those circumstances, what you do is to apply the exception to the rule and say, okay, which jurisdiction has the closest connection with the overall factual pattern as known as at the time this exercise is being carried out.
That strikes me as a confusion as confused thinking. But then that's not really what Chaplin and Boys is about.
Yes. No, I agree, my lord. Yes. It is a confused way of looking at it, but I think what I would say is that the overall conclusion is a perfectly reasonable one, which is looking to see which is the likely law that's going to dominate the trial. And that's really what he was doing. And as I said a few minutes ago, I think he's gone down a slightly false path in getting tangled up with double actionability in Boys and Chaplin.
Yes, so he's ended up in the right place, albeit he's taken a rather eccentric route.
Indeed, yes.
Right.
And so that's what I was going to say about applicable law. I'm very conscious of the time. In terms of the jurisdiction of incorporation, I adopt everything learned friend Mr. Rees said about that. The question is there some BVI public policy you can pray and aid? And this was the issue raised by learned friend my learned friend's colleague slightly on the hoof on the application for leave to appeal, because the application itself didn't identify public policy jurisdiction incorporation being a predominant factor where fraud is involved. That's a ground advanced on the hoof as being of general public importance.
It's interesting to see the way the judge actually deals with it. If you, in the hard copy, it's on page 121. I'm afraid I don't know what the E number is.
Not yet.
It's where it's internal page 45 of the judge's the transcript.
Yes, and essentially it's all...
Just use a moment, we'll have to
I'm sorry.
help those who are working from laptops to find the passage.
Internal page 38 of the transcript. Page 114 on the hard copy and 126, I think, of the electronic number.
Well, and I'm 7 pages into that, in that case.
I think my lord was thinking of
121,
lines 8 to, or rather, I suppose, from lines 3 to 14.
Well, as I well know, actually, it rather looks to me as if he's summing up his thinking at what appears at lines 14 onwards, where it seems to me the balance is tipped towards recognising the BVI as distinctly the more suitable forum on account of the breadth of remedies. So that's the tracing and proprietary remedies available in circumstances where the alleged fraudsters deliberately decided to use a preponderance of BVI companies to perpetrate their fraud. So he's linking the use, the significance of the use of the BVI companies is that he's connecting that to the availability of the remedies which BVI law would provide as against a BVI defendant. I don't consider location and native language of witnesses, or the fact that some documents may be in Russian, or the fact that Russian laws are the lex causae of the employment relationship as factors which override the available remedies factor upon the facts of this case. I'm in no doubt, therefore, upon the facts of this case, that the BVI is the most appropriate forum. So the critical factor is remedies, and he's treating it as relevant that those BVI remedies, it's fair that they should be available where BVI companies have been used as the instruments of the fraud, and treats that as treats the remedies factor as overriding the competing factors on the other side.
Yes, I think my lord is right in the sense that the significance of this point in the judgment, and that's why I was looking at page 114, is I think not entirely clear. Justice of Appeal Webster says you should only be looking at the Spiliada factors.
Yeah.
And maybe he only does look at the Spiliada factors and isn't an important point. But I think what Learned Friend was I think, rightly saying is that Luby makes clear that public interest of itself shouldn't be a relevant factor.
Yes, and that's not what he's saying here. He's not actually, this isn't really being treated as a public policy factor. I think from memory there's something similar said, I'm just speaking from memory, I think it might be Lord Clark in VTB, but there is a passage in a case I've sat in where somebody makes the point that if you're using, say, English companies as the instruments of fraud, then there is some fairness in the remedies available under English law then being available to your victims.
Yes, but that's a question of remedies and substantial justice. I think it may come into the substantial justice aspect, which is perhaps what I should move on to next. As I say, I think the position one gets to is that Cayman has its own way of dealing with things. Yeah. There's no equivalent in the BVI. Justice of Appeal Webster's a BV Islander with a lot of experience and didn't seem to think that there was any such public policy in the BVI. In terms of substantial justice, it's important to note that there are similar remedies available. I think the learned friend took you to those remedies. There's also in the evidence of Mr. Korkov an analysis of what remedies are available. And an analysis of what's equivalent. To constructive trusts and tracing. I'm sorry, I'm just trying to get the right page reference. It's tab 68 of volume F and paragraph 137 and down to 145. And there he analyses the Russian equivalents for constructive trust and tracing. So whilst it is the case it's not a common law jurisdiction, those remedies don't exist in the way we would recognise them here. There are Russian equivalents that enable the claimants to have substantive justice according to Russian law.
We're not going to submit that this is some kind of procedural advantage, which is not a spilliard effect.
Well, in terms of the advantages, of course one has to take the jurisdiction as one finds it, which is the starting point. There is a different procedure available in Russia, and there is the issue about are you going to be in one court or two. All those issues are available to consider, and the Court of Appeal did consider them, and it formed a view. And again, you may form, if you were exercising discretion, you might form a different view. But the Court of Appeal was entitled to form a view about those various elements and decide that whilst it was going to be different and whilst it might be slightly rougher justice, it was still justice. Beyond that, there were two grounds of appeal that were advanced in relation to comments made by the Court of Appeal. First of all, as to what Mr. Justice Bannister had decided. This was ground 6. And all I'd say about that is if you look at the judgment, you can see that whatever may or may not have been said about Mr. Justice Bannister's ruling, what the Court of Appeal recognised was the fact that it was a ruling that was overruled by the Court of Appeal, and therefore its significance entirely fell away. The other thing was whether or not the judge was right in criticising the defendants for not filing a defence. Again, that was a comment by the way and of no real significance. Didn't play any part in the evaluation exercise that the Court of Appeal was carrying out. So those grounds just simply don't take matters any further forward. The last aspect, which I suspect won't attract you very much, was the Respondents' notice in relation to non-disclosure. I think all I'll say about that is that the facts of that are set out in paragraph 88 of the Court of Appeal's judgment. And Justice of Appeal Webster goes through all the salient facts. Essentially, what wasn't disclosed was the fact that the material the claimants were relying on their ex parte application was material that they had to return under an undertaking given to the Cypriot court, had to return to the claimants who had been obtained under a Norwich Pharmacy order. The material had to be returned and was only to be used for purposes of the Cypriot proceedings. And nonetheless, it was used on the ex parte application. And none of that was explained to Mr. Justice Ferrara. And what we say is that the Court of Appeal should have set aside the order of service out on the basis of that non-disclosure, regardless of any other ground. And that's, as I say, paragraph 88 discusses that in the Court of Appeal judgment.
They say they're not going to interfere.
The judge at first instance said that he didn't consider there was material non-disclosure, and the Court of Appeal said, well, that's a reasonable conclusion to come to, essentially. And we take issue with that on the basis you couldn't do anything worse than producing material that you weren't entitled to produce, and that you'd undertaken to the Cypriot court not to produce, and said nothing about it at all.
Seem to have done it on legal advice.
They say they did it on legal advice. But
So we got sort of concurrent findings there, haven't we?
you've got, as I say, it's not our best point.
Right.
I think, unless there's anything further I can assist the board with, those are my submissions bearing in mind.
But just for the sake of completeness, I found what I had in mind in Lord Clark's judgment in VTB, and it's a slightly different point. It's what he was dealing with there was the instrument of a fraud was a contract which had an English jurisdiction clause in it, and effectively he was saying that that was a relevant factor, because if you were being enticed into becoming a victim of a fraud through having part of it being England being held out as the jurisdiction, then it was only fair that there was a factor of fairness and pointed towards England being the jurisdiction to deal with to provide a remedy for the fraud.
Yes, that makes
So
sense.
it's a slightly different point.
It's a different point. And as I say, in relation to offshore jurisdictions, Cayman does what it does. Nobody else seems to have done the same. I'm very grateful. Thank you.
Thank you very much. And Mr. Griffiths. Thank you. Yes, Mr. Fenwick.
My Lord, I will try and stick to the 18 minutes that I meant to have left.
Yes.
If not, there are a few specific matters I want to deal with, and then some general points. My friend Mr. Rees criticised the judge, including as a factor the fact that these claimants had chosen to come to the BVI. I accept in a service out case that may have no weight at all. But in this case, where I think 9 of the defendants were incorporated in the BVI and the claimants were entitled as of right to come to the BVI, that is a relevant consideration when looking at the case as a whole, that they were entitled to do so. Secondly, learned friend Mr. Rees again took you to the De Brouwer report, showing money being siphoned off all over the world and then passed on and passed away, and said, well, none of that was paid to the BVI. What, of course, is plain from it when you look at it is that most of that money was paid to BVI companies. The fact that it was put into a bank account in Cyprus or Singapore or Panama or Latvia doesn't stop the money going to a BVI company. And indeed, in the case of Copist, the BVI bribe payer represented by Mr. Rees, Copist actually made a payment of money which must involve some act by its directors. In that context, it seemed to us appropriate, and it's one of 2 documents that I'm going to make available to the court. We've taken the extracts from the BVI Business Companies Act of 2004, section 96 onwards, and I'm just, if I may, going to describe what it is and hand it up, because Malone friends will be very familiar with it. It's a provision which requires a BVI company to keep records at its registered office, or if elsewhere, to know where they are, and those include minutes of meetings, resolutions of directors, and information sufficient to identify the company's transaction and financial position. So the BVI directors had a duty to have access to and to hold in preparing their reports records showing these transactions which involve the bribes. So to say there is no connection with the BVI when that is the case is simply incorrect. The fact that we can't find out much about what they've done is again a factor in the choice of BVI. And the public policy documents you were shown for Cayman. Of course, in Loeb and Cape, public policy considerations were not given weight. But in circumstances where there is a jurisdiction, such as Cayman, which holds itself out as acting responsibly as a financial centre and with companies established there, the courts have continued there to treat public policy matters, protection of the reputation and enforcement of the rules of BVI, of Cayman, as relevant. It's not to be suggested that BVI is like the Cook Islands may still be, or Nevis may be seen to be, somewhere which has a less cooperative approach. The regulatory regime in BVI becomes ever stricter, and there is an obligation. If I go back to the extract I'm going to bring in, the fact that a company has to hold records, just assume that all these bribes are received in BVI company accounts all over the world are not accounted for in any way in the books and records of the company held by the BVI directors. No other court is going to be particularly interested in that, but a BVI court may well be interested in enforcing its rules which are there for a salutary purpose and in order to protect the reputation of...
But there are liquidators in place, aren't there? Well, don't they have powers to investigate?
There are only liquidators in place for the ones which
You're paying for.
have collapsed. The ones which remain, which are currently the non-appearing respondents, 2, 3, 4, and 5, and 17.
That's right.
They haven't. And part of the Cyprus problem, which you've been seen about in background reading, is that the records of Giant Hill in Cyprus have been jealously protected from us. So we have no way of getting access to the transactions of any of those companies until we liquidate them. We can't liquidate them until we can get judgment. We can't get judgment until we can sue them. We're not allowed to sue them in BVI. Have to try in Russia. The likely end result will be zero and a successful fraud through a BVI company. Next point I want to deal with, if I may, is the suggestion which was brought up ingeniously by my learned friend Mr. Mobley Smith, that perhaps the Court of Appeal had in mind that although the lex loci delicti could not be ascertained, then there must have been some losses in Russia. He took you to part of Professor Ososkov's report, but he didn't take you to the next key paragraphs, and I'm just going to look at it very briefly. It's in volume F at tab 70. It's 1394 in the hard copy and 1438 in the electronic version. I think he got as far as 76, the alternatives, 77, background facts, unlawful activities outside Russia, none of the bribe payments in Russia, for the purpose of application of the article.
Sorry, I'm not with you. Page 1394.
1394 hard copy, my lord, yes.
And which paragraph are you reading?
77, middle of the page.
And electronic?
1438, my lady.
Starts off in order to determine.
In order to determine. And says, from the facts, corporate defendants engaged in allegedly unlawful activities outside Russia, none of the bribe payments in Russia, formal sources of individual defendants to provide better contract terms is irrelevant, only the place where the acts were committed matters. The place where losses were incurred by a victim is the place where prevailing amount of direct losses were suffered by a victim, As follows from background fact, prevailing amount of direct losses from the bribery scheme is alleged to have been incurred by trading located in Switzerland, as it was the primary seller of fertilizer, so its losses were suffered outside Russia. Because of that, Russia is not considered the place where losses were incurred, for the purpose of Article 247. He then deals with the learned friend's point over the page. It follows from the background that until recently, first claimant was the parent company of the second. This does not change my conclusion made above. The majority shareholder may be seen as incurring only the so-called reflexive pure economic losses related to diminution of value of its shares, potential decrease of dividends. Such indirect losses shall not be taken into account when applying Article 247(1)(4), which speaks about the single place where direct losses were suffered. Russian arbitrage courts apply high standards of proof when establishing the place where losses from a tort were suffered. Gives an example of a case about a web hacker. And then at 82, alleged unjust enrichment of corporate defendants took place outside territory of Russia, secret commission payments. They would also not meet the criteria. So the mere fact that out of an abundance of caution, the first claimant, the employer, was joined and the losses were claimed by both, simply isn't enough to raise any prima facie case of losses being suffered in Russia, quite apart from the fact the Court of Appeal never suggested they were and never attempted to include that in its argument. There was a suggestion that we had not included in our appeal, an appeal against the finding that Russian law applied to restitutionary remedies. We did. It's D27, 883 in hard copy, 899 in the electronic bundle. My Lady Black asked about the rule applicable for determining the governing law. That, of course, is Chapter 35 of Dicey. There are 3 extracts from it in the bundle, not particularly helpful. The rule itself, Rule 256, is at H244, and paragraphs 35.111 and 35.121 and 122 are also included in the bundle at H246, but I've arranged for full copies of Chapter 35 to be provided. And what I'll do, if I may, is to hand up copies of both of those as I sit down, rather than interrupt what I'm going to say. Those were the specific matters I wanted to raise. If we stand back from the weeds and come back into the high ground of principle, the Court of Appeal found that the learned judge erred in 3 respects. Firstly, in concluding yes, it's paragraph 71, page 66, electronic, 62, hard copy. He didn't make a specific finding of the governing law. He shouldn't have relied on Rule 18.2 of Dicey. Both of those I've dealt with. Both of those we say are wrong and no ground to interfere with the decision and discretionary decision of the judge at first instance. Thirdly, attaching too much weight to the use by the Russian defendants of companies incorporated in BVI, the fact that the claimants chose to sue in the BVI, and says they're neutral considerations. In my submission, they are factors. I don't accept that the judge gave too much weight to them, but it simply cannot be said that by giving them some weight, the rest of his reasoning is so flawed that this court should permit them to interfere with the generous ambit given to the discretion of the judge at first instance. And the judge at first instance was entirely correct in our submission in concluding that Russia was not an available forum because it could not be shown clearly on the balance of probabilities that it was applying the test both available for these claims because of the disagreement between experts, lack of evidence of lex loci delicti, or the most suitable place for this action to be tried. And the main reasoning of the Court of Appeal therefore falls away. We also say that in considering the case against the service out defendants, the learned judge was entitled to conclude that Russian law was not such a factor that he had to give weight to it, and was entitled to take account of both the difficulties in availability and the other factors which he identified, and in particular the remedies which were available as of right to the claimants in terms of tracing in BVI as grounds for preferring the BVI as the appropriate forum. And just standing back again for one last second, in this kind of bribery case, where monies are hidden around the world and moved around the world, the tracing remedies available in a jurisdiction such as BVI or England are crucial to the effective prevention and detection and punishment of that kind of fraud.
Do you go so far as to say that their absence would mean that the forum was not really an available forum?
I would go so far as to say that in this kind of case, the forum is not available because a Russian forum does not provide a sufficient access to justice, because without tracing remedies, these monies will never be traced. I would also go on to say that applying Spiliada, Abdelhema, if I get that. What? Aberdeen-Deva, late in the day. They give a juridical advantage, which is a significant factor. So for all those reasons, we invite you to uphold our appeal.
What if I might just comment on the document that was handed to me 10 minutes ago?
I now don't know if we have this. Or is this the one that's just been given to us?
Yes.
I was going to ask about that they've got a Business Companies Act. Was that put in by Mr. Fenwick? Business Companies Act 2004, that's come from someone.
It's the act on which all the BVI companies are
Yes, but you said something about the transactions, but I see from section 98, the company shall keep at its registered offices registered or such other place or places within or outside the Virgin Islands as the directors may determine the records and underlying documentation.
Yes, the directors have control over that location. They have to be told when they're moved and so on.
So it doesn't have to be in the Virgin Islands, but they have control.
They don't necessarily physically have to be in BVI.
Okay, thank you.
Yes, Mr. Noblesmith.
The point I was simply going to make is that if you look at the marginal note against Section 98, you can see that this was a provision introduced in 2015.
Yes.
There was no equivalent provision before 2015. And you may recall from the statement of claim that the alleged bribery took place between 2005 and 2014.
Yeah.
Therefore, before any of these provisions came into force.
I see.
But if there were tracing claims, then you wouldn't be worried about the date would be not a matter which was material.
Well, I think the position would be that after 2015, records would then need to be kept. Whether that assisted with tracing is obviously a different matter. But
Well, we're grateful to Council for all their submissions, both written and oral. We will now take time to consider the advice that we shall humbly tender to Her Majesty.